Good morning, ladies and gentlemen, and welcome to our latest building webinar, an essential construction law update in association with law firm Fenwick Elliott. I'm Sarah Richardson, the editor of Building, and I'll be your chair this morning. With me, I have two expert speakers from Fenwick Elliott, David Bebb and Jatinder Garcha, who are both partners in the firm. We have three main topics for you this morning. First, David will give us an update on the tender process and how to avoid potential pitfalls. Then we'll come to Jatinder, who will tackle probably the biggest topic preoccupying the sector at the moment, Brexit and what it means for the industry, looking in particular at the legal environment for construction. And then finally, we'll go back to David for another hot topic, which is BIM and how to recognise and understand your obligations. Each of our presentations will last just under 15 minutes, and then we'll have some time to put your questions to the speakers at the end. And although we'll come to those questions after the presentations, you can submit questions at any point during the webinar, so please do send them over as you think of them using the button on your screen. We should be in for a very interesting hour, so without further delay, I'll hand over to our first speaker, David Bebb.
Thank you, Sarah. Now, the purpose of this webinar is to give those involved in the tender process, including employers, contractors and the professional team, a brief reminder of the key bits of law that govern a typical private sector tender. As many of you will know, it's often breaches of the public sector tender process that find their way into the courts, and private sector tends to cause few problems. However, this doesn't mean that anything goes in the private sector in terms of how a tender is conducted. As I will explain, a typical set of tender documents in the common law do set out some rules of the game, and it's a breach of these rules that can trigger a claim. For example, a disgruntled contractor may be able to claim not only his wasted tender costs, but potentially his loss of profit on the job. In principle, a disgruntled subcontractor could also sue a main contractor on the same grounds, and the professional team don't escape either. In one case, the employer also sought to sue his architect, not only for advising him that the way the tender process was being conducted was in breach of the rules, exposing the employer to a claim. Now, as I've mentioned, please note this webinar is limited to private sector tenders and does not cover the public sector. So what are the rules of the game? Well, there's two sources. First, the common law, and second, the tender documents themselves. Both rely on there being a tender contract. In other words, a contract that governs how the tender will be conducted. This is totally separate to the contract for the actual work itself, which obviously may or may not be entered into at the end of the tender process. Now, in relation to the common law position, the Blackpool case and a number of other cases recognise that an implied contract can exist at tender stage. Now, the precise terms of that contract will vary, but it may include, as it did in this case, an obligation to treat a tenderer fairly, for example, by at least considering a compliant tender that was submitted on time. In this case, the court said the tender could not simply be ignored. Any breach of an implied contract can give rise to damages in the usual way. However, we don't need to look at the common law position in detail, because the way typical tender documents are written, it's often the tender documents themselves that cause the most problems, because they contain express terms, and so a disgruntled contractor does not need to clear the hurdle of showing there's an implied contract governing the tender process. So what are the rules in the tender documents governing a tender? Right, this slide contains a number of relevant extracts from a typical set of tender issue prelims and extracts from a JCT Practice Note. I suspect these are often cut and pasted from one tender document to another without very much thought going into what they say, and rarely will the parties give very much consideration to them. When was the last time you looked at the JCT Practice Note, for example? But it's these provisions that the courts have said form some of the rules of the game. It's also important to note that the general theme running through the JCT Practice Notes, at least, is a sense of fair play in how the tender is conducted. In effect, it recognises that submitting tenders can involve significant time and cost for a main contractor. So even if you cannot identify a particular clause that's been breached, this does not mean you're on safe ground if you depart significantly from the intent that the process should be fair. Note in particular the final point in this slide about not altering prices without justification. This is actual extract from paragraph 61 of the JCT note. Now, the sort of justification that JCT has in mind is a change in spec. In other words, prices can be reduced, but only in return for a lower spec or some value engineering. If the employer doesn't want to change his spec, but simply wants to pay less, this may not amount to a justified change in the tender prices. Now, the problems these provisions can cause is best illustrated by a Northern Irish case of J&A Developments. Although this is a case of Northern Ireland, the English courts may well follow it. Now, this was a tender for the construction for a new workshop. J&A was the contractor, Adina the employer, and ADP were the employer's architect, effectively running the tender process. Now, in this case, the prelims in the tender documents referred to a tendering code of practice, very similar to the JCT one I mentioned earlier. This contained the wording along the lines that the NIJCC, and these were the killer words, strongly deplores any practice which seeks to reduce any tender arbitrarily, where the tender has been submitted in free competition, or to reduce tenders other than the lowest tender to a figure below the lowest. Now, this was a fairly tight tender. Tenders all came within about 10% of each other on a contract sum of around about £1 million. However, not content with this, the employer called a meeting with the 3 lowest tenderers, at which they were all asked to reduce their prices, but without any corresponding change in spec. In effect, the employer held a form of Dutch auction and played the contractors off against each other in order to reduce the prices. Now, J&A refused to reduce their price, but the other tenderer agreed to reduce his price by about £25,000 and unsurprisingly was awarded the contract. Now, J&A, who were the most certain to have won the job, had the employer played by the rules, then sued for their wasted tender costs and their loss of profit on the project. So what did the judge say? First, the code was binding on the employer because of its inclusion in the tender documents. Second, the code provided that arbitrary reductions in price were deplorable, and the judge held that the employer's conduct breached this provision. The contractor was awarded damages for his wasted tender costs and his loss of profit, which came to over £130,000 without having done a bean of work on site. To top it all, the employer then tried to sue his architect for failing to warn him of the risks of how the tender process was being conducted. Although the court held the architect was not liable, you can imagine that the claim came as a bit of a shock to the architect. This is something that PMs, architects, QSs, etc. involved in the tender process should bear in mind. So what tips can be gleaned from this case? I think first, assume that a contract applies to the tender process. This may be implied along the lines of the Blackpool case, or because of the way the tender documents are written. More likely the latter on larger projects that incorporate the JCT code or similar codes of practice that govern tenders. Secondly, consider very carefully what the terms of that contract are. Treat this as you would any other contract. A breach can trigger damages in the usual way. In terms of tips for employers and the professional team, they should review the prelims and tender documents very carefully. Do you actually know what they say? Do you want to conduct your tender differently? If so, you need to say so. And I think bear in mind as well that how ruthless do you want to be in that tender process? If you're going to hold a Dutch auction or the facts from J&A case sound familiar, then you should think about how clear the wording needs to be in those tender documents. At least this way the contractors know the rules of the game from the outset and can decide whether or not they want to take part in that game. From a contractor's point of view, having perhaps had a bit of a rough time bidding the main contract, think about how you conduct the tenders for the major subcontract packages. I suspect in many cases the process is pretty informal and a set of drawings are issued to the 2 or 3 subcontractors and a price requested back by a specified date. Then what happens? Is the process very much like the J&A case? Bear in mind as well that if you send the main contract prelims in the subcontract documents, do you incorporate that JCT Practice Note as well via the back door? From the professional team's point of view, is the employer savvy enough to know the rules, or is he or she relying on you to guide them through the process? At what point do you step aside and advise them of the potential pitfalls? I think finally from the professional team's point of view, consider professional conduct rules. If there's a process that departs significantly from industry accepted rules of fair play. Now, contractors often rely on the involvement of the professional team as bringing an element of impartiality to the process, as they do during the administration of the contract itself. How are contractors likely to react if the professional team refuse to get involved in the negotiation once the initial tenders have been received back? There are certainly certain professional conduct rules that govern concepts of not bringing the industry into disrepute, etc. Those sort of things may well bite if you're a member of RIBA, RICS, etc. Now, in summary, it's probably fair to say that the claims in the private sector for abuse of the tender process are rare, but perhaps this is more a reflection on the buoyant construction market over the last few years. Inevitably, there will come a downturn at some point, and perhaps this is the time to dust off the tender documents and make sure you know precisely what the rules of the game are. Okay, thank you, Sarah.
Thank you very much, David. Really interesting opening presentation. Do remember that you can ask a question at any time. We've got a few coming in already, so do keep those coming. And now I'm going to hand over to Jatinder, who's going to talk to us about Brexit.
Thank you very much. Good morning, all. For this part of the seminar, we'll be looking at the consequences of Brexit for the UK industry. I shall very briefly discuss the commercial implications and recent trends seen since June's historic vote, then look at a couple of legal and contractual issues, and then finally touch upon some positives or potential opportunities that could come out of leaving the EU. In the immediate aftermath of the vote, we saw a slowdown in certain sectors, in particular in the commercial property sector. Some projects were, and some still are, put on hold as investment decisions are delayed until there is a better clarity on the UK's relationship with the EU. Unfortunately also, there were a number of projects that were abandoned altogether. Now, following this initial reaction, no real impact has been felt, and it's been largely business as usual. But I don't think anybody is under the illusion that that will continue to be so. That it will continue to be so for the long term. Certainly, in the medium term effect of Brexit will only be seen once the current legacy projects have been completed, and more importantly, once Article 50 has been invoked and the real panic has set in. In the long term, there are a number of potential issues for our industry. Firstly, the UK has to a large extent relied on migrant workers from the EU to fill its current skill shortage. This will be hit by the new restrictions on immigration. But whilst the EU citizens already here are likely to be able to stay, this pipeline will severely be restricted in the future. Shortages in skilled labour in themselves will lead to higher labour costs potentially. In addition, the weakening pound is pushing up the price of materials. Add to that the potential long-term problem of imposition of import duties and quotas by the EU, which could also affect construction exports as well. So, it doesn't paint a particularly good picture. Contractors may well see their margins squeezed as input costs therefore increase, but a fall in demand domestically may result in growing competition and, who knows, even a fall in tender prices. In addition, the UK will lose access to the European Investment Bank and the European Investment Fund, which has invested billions of pounds over the years in UK infrastructure projects. Now, this loss may in some part be offset by the savings to the UK for not paying the EU membership, but I still think it's still going to be in practice a big loss. Now, moving on to the main purpose of this part of the webinar, which is to consider any legal or contractual implications of the Brexit vote. The first thing to note is that other than CDM regulations and some energy performance requirements, there is minimal construction-specific EU legislation. However, one area that does touch and concern the construction industry is that of public procurement. Now, Dave's touched up and talked about private procurement. Here I'll be talking about public procurement only. Now, one of the criticisms aimed at the EU was that its bureaucracy and in relation to public procurement, its over-regulation and the additional delay and costs incurred, and on occasions, its lack of flexibility, which I mean especially in circumstances where a public body has a good reason to use a specific contractor quickly, but is unable to do so because of the rules. In fact, following the vote, I heard clients say, well, at least we now won't have to deal with the EU procurement nonsense anymore. But I'm not sure that is entirely correct. At the moment, the UK is still part of the EU, so the EU procurement rules continue to apply. The EU public procurement rules are enacted into UK law by the Public Contracts Regulation 2015 and the Utilities Contract Regulations 2016. Now, these regulations will continue to apply in the UK even after the UK has formally left the EU, unless there is a specific repeal of these laws by Parliament. Now, whether changes will be made to the existing UK procurement rules is dependent primarily on the type of exit relationship the UK negotiates with the EU. The options are as follows. First of all, the UK may decide to have full access to the EU's internal single market by becoming a member of the European Economic Area, which is also known sometimes as the Norwegian model. Such membership would, in all likelihood, require compliance with all EU legislation, but unfortunately without any rights for the UK to have any say in how this regulation is shaped, as it's no longer part of the EU. This would appear to be the worst of both worlds. Add to that the fact that such membership would also likely involve the free movement of labour, one of the key battlegrounds for the Brexit vote, then it looks even less attractive. If, however, this route was chosen, then no changes to the current EU procurement legislation would be necessary. Secondly, the UK may decide to forego access to the single market and instead comply with the World Trade Organization's Agreement on Government Procurement, assuming that is that the UK is a member of the WTO in its own right. Now I say that because at the moment the UK's membership of the WTO is via the EU, and obviously the UK would have to have a specific membership going forward. So what is the GPA? The GPA is a multilateral agreement signed by WTO members allowing access to each other's public procurement markets by their home suppliers. Now the GPA is an agreement which sets out rigorous rules on how procurement must be carried out. The agreement itself is important to the UK as it would allow access to UK businesses to, amongst others, the USA, Japanese and parts, but not all, of the EU markets. However, the GPA contains substantially the same key arrangements as the EU procurement legislation. In fact, the EU procurement directives are themselves compliant with the GPA rules. So whilst this approach would allow the UK some flexibility, in reality minimum changes to the current procurement legislation would be necessary or likely to be made. Thirdly, the UK may decide to take this as an opportunity to produce a whole new procurement philosophy or to streamline the current process whilst potentially staying within the parameters of the government procurement agreement. Trying to make any radical changes may be difficult, however, as any changes may be restricted by the terms of any international trade agreements signed by the UK following Brexit. It is also very unlikely that public procurement rules and legislation will be dispensed with altogether. Ultimately, the underlying principles of obtaining best value and maintaining transparency and accountability when spending public funds will, and quite rightly should, continue to apply. This all unfortunately appears to point to the fact that very little change is likely to the current procurement rules. On a more positive note, however, it should be remembered that even where the current procurement legislation is not changed, once the UK has formally left the EU, any challenges under these rules will no longer be referable to the European Court, but will instead be dealt with solely by the UK courts. It will be for the UK courts to interpret our rules and regulations. Coming then onto contracts. Now, I am myself a non-contentious construction lawyer, which means that I draft and negotiate construction contracts. And I shall be advising my contractor clients in particular to ensure that any contracts entered into during this hiatus period, before the full exit terms are known, adequately cover for the following. Firstly, changes in law occasioned by Brexit. Now, given the current state of uncertainty, to the largest extent possible, this needs to be a risk that should sit with the employer, I would argue. Now, drafting contracts, it's not unusual to see provisions within the contract state that the contractor is entitled to an extension of time, except for those changes which are reasonably foreseeable. Now, given that we all know that we're Brexiting and that some change in law is going to be necessary, it's very difficult at this stage to decide and argue what is reasonably foreseeable at this stage. Also, given what I said earlier, that there is very little construction-specific legislation, when we're talking about changes in law, I think we need to look a little bit wider, import taxes and etc. Secondly, in relation to long-term projects, and here I'm talking about projects which potentially may still be running once we have formally exited the EU. For these type of contracts, you need to make an allowance for increases in material costs and imposition potentially of import duties. But more difficultly, the issue of unavailability of skilled labour needs to be addressed, whether this is done expressly or by reference to the force majeure provisions. Now, how to address this in practice will take a little bit of further consideration, as well as the consequences of it being either a compensation event or a force majeure event. But it's certainly something that needs to be taken into consideration. The reality is that the decision to leave the EU has been taken, and we're all going to have to deal with the fallout. A recurring theme when speaking to contractors and consultants is a real concern about how the skill shortage will be plugged. Now, given that we have at least 2 years before the UK formally leaves the EU, we should perhaps use this Brexit vote and that time that we have as an impetus to increase apprenticeships within the industry and look at ways for the construction companies to invest in training up its own skilled workforce. We could use it as an opportunity to put our house in order. Now, how this will be done, I'm not entirely sure, but I would be grateful for any comments and views that any of you have out there listening at the moment. To date, the skills shortage has been filled by migrants from the EU. But following Brexit, it will allow talent from the rest of the world to compete for jobs on a level playing field with those from the EU, which again may be beneficial. I think we have for too long been missing out on talent from outside the EU, as the market has been flooded by EU labour. And finally, if investors do decide to take their money out of the UK property market, that will potentially lead to a result in cheaper sites and or more sites becoming available, perhaps to help our acute housing shortage. So there are potential opportunities and positives from Brexiting, but ultimately we are living in very uncertain times, and nothing at this moment in time is predictable, but your comments and views would be welcome. Thank you.
Thank you very much, Jatinder. Nice to end on a positive note there about Brexit. So as Jatinder says, do send through your comments and also your questions as we go into our final presentation, which is going to be from David on BIM.
Okay, thank you, Sarah. I'm going to cover 3 areas in today's webinar, which will focus on the more important legal rather than the technical issues around BIM. First of all, I'll take a look at how BIM Level 2 is currently treated by the 2 main standard form contracts, namely JCT and NEC. I'll include within this how the new JCT 2016 contracts deal with BIM, as well as the 2011 contracts. I'll also look at a few problems that may arise. Secondly, I'll look at the CIC BIM Protocol, which was published by the CIC back in February 2013, and specifically deals with the use of Level 2 BIM. Again, I'll look at a few of the issues that arise. And finally, I'll consider some of the issues around the government soft landings programme and how this will sit alongside standard building contracts. Now, although JCT has launched its 2016 contracts and is in the process of gradually releasing the full suite, experience suggests it may take some time for the industry to adopt these, and we expect that the 2011 contracts may still be used for some time yet. On this basis, I thought it would be useful to recap on how JCT 2011 deals with BIM Level 2, before then looking at the 2016 contracts. Now, BIM is dealt with in the JCT Public Sector Supplement 2011, which can still be downloaded from JCT's website. Now, JCT's view is that any BIM protocol can simply be incorporated as a contract document. As you all know, because the contractor is required to carry out work in compliance with the contract documents, normally around clause 2.1, this does the trick in terms of incorporating a BIM protocol. All very simple then. Now this can be done either through incorporating the protocol in the prelims or the ERs, or just naming it as any other contract document. Now JCT helpfully includes some suggested drafting to incorporate a BIM protocol, but essentially this is simply amending the definition of contract documents to refer to whichever protocol you've agreed will apply. JCT 2016 contains specific provisions dealing with BIM, but adopts a very similar approach to 2011 in that it treats any agreed BIM protocol as a contract document. The 2016 contracts provide for a new entry in the contract particulars, so you can identify your BIM protocol there, and then clause 1.3 that deals with priority of documents then goes on to say that the conditions, i.e. clause 1 to 8 of a JCT, override any other contract document, which would of course include your BIM protocol. So the conditions are intended to trump the BIM protocol. Now JCT's view is that such discrepancies should not arise. I'll touch on this a bit later when I look at the CIC protocol. Next up then is NEC, which of course is the government's contract of choice. Now given that BIM Level 2 is now compulsory on government projects, it's perhaps this contract that's going to be used the most often rather than JCT. Now the NEC's original view on using BIM was that no changes were necessary and it was sufficient to slot the BIM protocol into the works information, or in the case of an NEC professional services contract, to slot it into the scope. So in effect, much the same approach as JCT in treating the protocol as another contract document. However, NEC has since updated its view in its recent guide. The how-to guide recommends that the obligations in a BIM protocol are divided into two categories. Those dealing with the technical requirements should be included in the works information or the scope, and those dealing with the parties' rights and liabilities should be included in the conditions of contract. To be honest, I've not actually tried to see how easy this is in practice. The reason why the how-to guide draws this distinction is because items in the works information or scope can be varied without the contractor's consent. Remember, it just needs an instruction from the project manager. Whilst this is acceptable for scope requirements, which will be picked up in the compensation event mechanism, it's obviously not acceptable for provisions relating to the parties' rights and liabilities, which should require both parties' agreement to amend. Now NEC has provided the relevant Z clause, so it should be a simple case of looking at your proposal and dividing the technical requirements from the legal bits. Right, so having looked at how JCT and NEC incorporate a protocol, let's have a look at exactly what a typical protocol does and some of the legal issues that may arise. Now, the purpose of the CIC protocol is to integrate BIM Level 2 with standard form contracts, and it essentially sets out the rules of the game for how your project will adopt BIM. Now, whilst the protocol is well known in the UK, it's arguable to what extent the protocol is used. Interestingly, in recent research carried out by the King's College London, very few interviewees mentioned adoption of the CIC BIM protocol. This does tend to beg the question which protocol the parties are using, if at all. Nevertheless, if using the CIC protocol, or any other protocol for that matter, it's important to understand what the protocol attempts to do in terms of each party's contractual obligations and how it sits alongside the main contract or the professional team's appointment documents. So what are some of the key issues that arise then? Now first, the protocol is designed to take precedence in the event of a conflict with any other contract. Have a look at what clause 2.2 says in that protocol. As such, there's a real risk that interpreting the wording of the protocol alongside the contract provisions, in particular standard forms which are not amended, will be problematic. Remember what I mentioned about JCT 2011 and 2016? Both suggest that a protocol, not necessarily the CIC protocol, should be a contract document. And then it went on to say, obviously, that the conditions of the JCT will override any other contract document. Now, if the CIC protocol is used without amendment, there's clearly a risk of a conflict from day one. The JCT is saying its terms should take priority, where the CIC is saying its terms should trump the main contract. If the parties are using NEC, this problem should not arise, as the rights and liabilities in the protocol should have been separated out and included within the Z clauses or the works information, so that problem should not arise. Secondly, the parties should be aware that the protocol includes limitations on a project team member's liability. Clause 4.1.2 provides the obligation on a project team members to deliver models and comply with the information requirements is limited to reasonable endeavours. This duty of care is lower than the more typically accepted reasonable skill and care for a consultant, and definitely lower than a contractor's obligation to comply with the contract documents, which is an absolute obligation. Clause 5 provides that the project team member does not warrant the integrity of electronic data. I think that just means whether the data is any good or not. And clause 6.4 provides the right for a project team member to revoke or suspend a license to use their models in the event of non-payment. Now, JCT contracts are frequently amended to exclude the right to suspend a copyright license on the basis of non-payment, and so once again another conflict may well arise in terms of copyright and payment. Now, regardless of whether the CIC protocol or your own bespoke protocol is used, all parties need to understand where the obligations and duties of care are either heightened or diluted from the industry norm or other contract documents. In addition, with numerous documents setting out the BIM procedures and the standards for the project, parties need to ensure they are aware of their obligations within each document and understand how they'll fit together, both in terms of priority as well as process. For example, time and deadlines in terms of model production are not dealt with in the CIC BIM protocol, but instead left to the BIM execution plans, a totally separate document. Furthermore, clients' employers should note Clause 3 on the protocol imposes an absolute obligation on them to ensure that all members of the team sign up to the protocol, or at least one substantially the same. It's not really clear what the sanction would be if the employer failed to do this, but obviously the project would have failed to achieve its BIM Level 2. The final part of this webinar looks at the government's soft landings. In short, this is a government's management approach to the specification and measurement of building performance, based on the philosophy that the ongoing maintenance and operational cost of a building during its life cycle far outweighs the original construction cost. If this can be recognised during the design process, there will be greater scope to achieve cost savings and improve functionality during the life of the building. Now, the fact that maintenance costs can far outweigh build costs is nothing new, of course, but this is an attempt to better capture the data and influence the design from the very beginning. The GSL's primary focus, therefore, is on functionality and effectiveness. Buildings should be designed to meet the needs of their occupiers. Buildings should meet government performance targets in terms of energy efficiency, water usage, waste production. In relation to facilities management, there should be a clear, cost-efficient strategy for managing the operations of buildings. And finally, projects should be delivered, handed over, and supported such that they meet the needs of end users. Now, from a legal perspective, the GSL is likely to create more contractual issues since it raises a brand new concept of responsibility for the whole life cycle of buildings, which involves the setting of targets, measuring of performance against those targets. The post-occupancy period during which a building is monitored is intended to last for 3 years after practical completion. In other words, this post-occupancy period is 2 years longer than a traditional defects period. Now, this is not something that standard building contracts presently deal with. Therefore, amendments to standard forms will be necessary to provide for the associated extended monitoring on site, which may or may not overlap with the defects period. Amendments may also be necessary to provide for the precise maintenance and operational requirements and standards that need to be met during the life cycle of a building. This may lead to a shift towards routine fitness of purpose obligations and absolute warranties, which are currently construed very narrowly by the courts in the absence of very clear words. In other words, will contractors and the design team have to sign up to an absolute obligation that the building will achieve a certain performance? And what happens if it doesn't? Even before the days of BIM, designers were often required to design to meet certain performance criteria, but the close monitoring of this for 3 years after PC brings it much more under the spotlight. So I think in conclusion, what can we say? I think no matter what contracts, protocols, etc. are required on a particular project, it's important to understand exactly what your obligations are. Unfortunately, the courts are littered with cases where documents conflict with each other and obligations are not fully understood. With regard to BIM, the devil is in the detail with these documents. Check whether your contract or appointment still hangs together to deal with these additional obligations that could be contained not only in a protocol, but in various ancillary documents such as execution plans and model plans. Finally, and perhaps on a more positive note, there are no insurmountable legal problems with Level 2 BIM. It just needs a bit of thought as to how the additional obligations are dealt with and the contracts tweaked to deal with them. As more projects adopt BIM, these issues will get ironed out. Thank you, Sarah.
Thank you very much, David. Another really interesting presentation. We've got lots of questions coming in, so we should really start answering them, I think. So I'm going to stick with David for now and go back to our first topic of today on the tender process, as we had quite a few questions come in near the start. So first one is from Paul Marriott. If the tender documents include the provision that the client is not bound to accept the lowest tender, does this alter the legal position if further negotiations take place? David?
The very short answer to that, Sarah, is no, it doesn't, because that wording you'll recognise from all standard prelims documents. It says effectively the client reserved the right to accept the no quote at all, but that was actually commented on in the J&A case, and the judge said that wasn't enough. That was simply one of the rules of the game. So one of the rules of the game was that the employer doesn't have to accept any tender. For example, he may not have the funding in place or various reasons why it's exceeded his budget. The court said that was insufficient. There are other rules of the game, and the main one of the rule of the game that the judge picked up in that case was the fact that you couldn't make arbitrary reductions to the price. So in a short answer, Paul, it's not enough.
Thank you very much. And still sticking with you on the topic of tenders, we have a question come in. I assume that a clear scoring criteria in the tender document, as long as it is adhered to, mitigates some of the risk of being open to challenge.
Yes, it does. It does mitigate that risk, but what you've got to bear in mind, as I mentioned in the seminar, you need to treat the whole tender process as a contract that's made up of a number of different terms, all of which you could trip over. So this is one you could trip over, but even if you stuck to the tender criteria for assessment, so if you were to say it's all quality driven, or it's all price driven, or you give weightings to that, it still wouldn't stop an employer who was particularly ruthless from then saying, well, actually, I'd like an arbitrary 10% off that, please. So you would still fall foul of that in that situation. But it's going to help a lot, obviously. The more you stick to all the terms, it's going to help mitigate it, but it won't prevent it completely.
Thanks very much, David. And though not common practice, in a two-stage tender, how binding is an NTE figure given at the first stage? That's a question from William Jarrett of Mace.
That's really interesting. It really depends on exactly what they're asking to do in your tender document. So bear in mind again that this is a contract. I've seen tenders now before with wording on the lines that I, as the contractor, warrant, remember the word warrant in particular, that my price based on what you've given me so far will not exceed £30 million. There's a serious risk that could actually bite, because you're warranting that based on the information you've given at the time, it will not exceed whatever the price it is. I've done this recently for a contractor where I said that needs some real watering down. So what we agreed to do was to say, based on the information available at the time, the state of the design, the current market conditions, we will warrant that to the best of our knowledge, we think we can bring this project in at a price of X, but it needs really watering down, because otherwise I see no reason why, based on pure contractual terms, a warranty like that could not stick, although I'm not aware of any particular case law bang on that point, William.
Thank you very much, David. And one more for you for now. JCT Contracts, does it state in the contract that trying to reduce a tender by methods such as a Dutch auction is not acceptable? And if so, where?
No, it doesn't say exactly that, but the devil's in the detail. So if you look back at my slides, it's actually in the JCT Practice Note. It's actually paragraph 7.1. It's snuck in there. And it says good practice demands that a contractor's tendered prices should not be altered without justification, and that's what, in that case, J&A hung their hat on. They were saying, well, you've got no justification to change my prices because your spec hasn't changed, you just don't want to pay as much, and that's what they hung their hat on. So the answer to that, it's in paragraph 61, but doesn't say expressly. And that sort of brings me around to my point about, well, given it's a contract, what do you want to be able to do in that tender process to reduce the prices? If you do want to hold a Dutch auction, which in fairness to contractors probably would take umbrage to, you need to say so very clearly, because otherwise you might fall foul of what that JCT Practice Note says.
Thank you very much, David. Now I'm going to give you a little break and come over to Jatinder with some questions that have come in on Brexit. The first one from Matthew Dennis. You mentioned the WTO agreement in your presentation, Jatinder. Very briefly, what does that agreement set out?
Well, what the agreement does is to set out the rules how procurement must. Sorry, what that agreement does is to set out the rules on how procurement must be carried out. Now, what it also does, it sets out the basic principles, such as the rules on technical specifications and advertisements. It pretty much sets out the same kind of rules and standards and regulations that we currently have in force under the EU regulations of what has to be provided when and the technical specifications of that in a nutshell.
Thank you very much, Jatinder. And you were talking about the relationship between the UK procurement rules and the EU requirements. We have a question come in. To what extent are the current UK procurement rules the minimum EU requirements, or has the UK added additional requirements over and above?
Good question. On those areas of public procurement, that are the same, and I'll come on to what I mean by the same, between the UK and Europe, all of those public procurement regulations are based upon EU directives, and accordingly they are effectively passed into UK law as they are, and the UK has not added any additional requirements on top of those. But what has happened is that the UK itself does have additional procurement laws which do not derive from European law, and an example of that is the National Health Service Procurement Patient Choice and Competition No. 2 regulation of 2013, which relates to how commissioners purchase health services from the NHS and thresholds in that respect. So that's something that's outside of the EU regulations because it's not something that is covered by an EU directive. But to the extent that it is covered by an EU directive, then it is passed into UK law almost as it is without any additional requirements on top asked for by the UK government.
Thank you very much, Jatinder. And one for you, I guess this is sort of a million-dollar question, but I'm going to ask it anyway. You were talking about the impact of Brexit on tender prices earlier. We have a question coming from Mark Davison. Do you have any thoughts on when the devaluation of the pound is going to hit construction costs and by how much?
The million-dollar question indeed. Very difficult one to answer, certainly from me as a lawyer. I'm not on the ground, so maybe we might get some comments in from some contractors or consultants who are on this call to say what they think. But as we've seen with the Marmite fiasco, it's not going to take very long, I wouldn't have thought, for the additional cost to be factored in. For those of you, just so you're aware, the reason we say that the construction costs and input costs will increase is because a lot of the material that we use in the construction industry comes from abroad, and with the devaluation in the pound, what that means is that materials that were relatively cheaper before Brexit, now that the pound has been devalued, means that it's costing more to import because of the devaluation. But so I see that the cost itself will start being factored into the cost quite quickly, I would have thought. By how much? That is a question, and unfortunately, I'm not sure that I'm in a position to answer how that will be. But as I say, as we've seen with the Marmite fiasco, companies will soon be looking to put that cost up.
Thank you, Jatinder. Staying with Brexit, you mentioned in your presentation about provisions in contractors' contracts to cover the eventuality of any changes in law that might arise from Brexit. We have a question asking whether you expect a changes in law clause to be inserted in consultants' appointments, and if so, how are consultants to be expected to anticipate what those changes may be? Do you have any advice there?
Yes, I mean, as I did try to say in my presentation, we would ordinarily expect some sort of reasonable foreseeability test to be included when it comes to changes in law, whether it's in a contractor's building contract or in a consultant's appointment. However, it's very difficult to predict at this moment in time what is reasonably foreseeable, because we're all aware that Brexit's happening. We all appreciate there will be changes in law. But what those changes will be, it's difficult to foresee at this stage. So I think from a consultant and from a contractor's perspective, I think even trying to accept what seems to be a reasonable provision by an employer about reasonably foreseeable, I think in this is probably one of the contexts where it shouldn't be accepted, and it's very difficult to accept. Now, in relation to the point about whether consultants require changes in law, I can't see why not. Potentially, there may be changes in design specifications and standards that now need to be reflected following Brexit. But I think in reality, there's probably unlikely to be any such changes. I think the European Union is will still continue to be one of our biggest potential markets. And I think in order to comply with with that, we will have to comply with the European standards that are out there at the moment. And accordingly, I think the change in design risk, I think, is probably minimal.
Lovely. Thank you very much, Jatinder. I'm now going to move topic and ask a couple of questions that have come in on the topic of BIM. So the first one is a question from John Parson. Is there an obligation on the design team members to provide a single coordinated BIM model rather than separate models, i.e. the architect, M&E structures?
Do you know what, Sarah? I don't know the answer to that, but it will be specifically in the CIC protocol. I do have a copy here, but I'll be honest, I could answer your query afterwards, John, but it will be dealt with in the detail of the CIC protocol itself, because obviously, as I said in my seminar, that's what sets out the rules of the game to how it's governed, so it will be buried in the CIC protocol somewhere.
Thank you very much, David. And you were talking about soft landings in your presentation. We have a question coming from David King. What evidence is there that clients are willing to fund 3-year post-occupancy support?
I'll be honest, I'm not aware of any particular evidence that that has been taken in terms of whether they're prepared to fund it. I suppose you might see it from the fact that it actually benefits them rather than the contractor, so there will inevitably be an extra overcost included within the overall contract sum to manage that procedure 3 years after PC, but ultimately it is still to the client's benefit, of course. So there's no evidence as such, but I could imagine the contractors have got to price that, because at the moment they'll only price a 1-year, 12-month defects period, but actually in effect they're going to have people on site for 3 years monitoring that building.
Thank you very much, David. And just staying with you for the moment, a question about royalties in relation to the BIM model. Are they likely to be addressed in relation to the JCT?
Certainly JC haven't done it yet. If you're thinking about licensing royalties for copyright, etc., the way that's done at the moment is there's no concept and no provisions in there for royalties being payable. The only thing it does do is limit the scope of the license in there for the particular project. So if it's rolled out in other projects, there are provisions in the copyright allowances that allow that to incur a separate fee.
Thank you very much, David. I'm just going to go back onto the topic of the EU now, again, Jatinder. We have a question come in from William Boucher from Birmingham City University. How are you developing your advice to clients? Obviously, Brexit is a known unknown, but are there any sources that could help to inform on possible strategies for managing the turbulence that may result? Are there any, I guess, similar situations that you're looking at as a practice?
I don't think we are at the moment. I think we're still waiting for the Article 50 to be invoked, and I think on the back of that we will have a little bit of a better idea of what type of approach the government is going to take in its Brexit negotiations with the EU. And as I said to you in relation to public procurement, I mean, knowing exactly what type of approach the government is taking for the exit talks is going to be crucial, and I think it's only then, once we have an idea of what that approach is going to be, will we start looking into what potential changes may be required to contract, or what information and advice we need to start giving to clients. But I think at this moment in time, given the vagueness and the uncertainty, it's a little bit difficult to predict, and therefore I think it's a little bit difficult to advise as to exactly what clients should be looking at. But from my perspective, as I say, I'm a non-contentious lawyer and I look at contracts, and for me, certainly areas around risk in increases in cost, in skilled labour, what constitutes force majeure, whether we need to look at a broadening the description and definition of force majeure to capture other events. These are the kind of things that I'm looking at, certainly from the client's perspectives. But other than that, as I say, unfortunately, I'm not sure that there is any information out there that can be used or handed around or looked at.
Thank you, Jatinder. And another question on risk with Brexit. Regarding the allocation of risk when the Brexit changes do take place, what do you think is a reasonable allocation between the client and the contractor?
What are we talking about? Are we talking about the risk when Brexit has occurred and we have effectively left the EU? Which I think once we know at that stage, I think it's very simple. It will be what it is at this moment in time, because we will know exactly what the terms are of the exit and what trade agreements we've entered into and what the new life looks like post Brexit. At that point, I think we will have an informed understanding in the market, and accordingly, I think the same rules that apply now will apply, and I think the risk allocation will stay as it is, because we will know what the law is, we will know what the risks are, and I think everyone, and contractors in particular, will be able to price that risk. The question really is where the risk lies during this period of hiatus between us not knowing what's going to happen over the next 2 years and what the ultimate end negotiations will be. And I think at this stage, I think that from my perspective, is something potentially that we may be looking to put more risk back onto the employer on this occasion, because I think it seems rather unfair for contractors to be taking that risk when nobody's aware of what that risk might be. I think contractors may be willing to take known risk, but unknown risk I think is a little bit more difficult. So in answer, I think it depends very much on what period of time we're talking about. I think in this period of time it should be more for the employer to take a little bit more risk, and I think post-exit then I think we can look for contractors taking back more risk as they do at this moment in time.
Thank you very much, Jatinder. I'm now going to return to the topic of BIM, as we've had a few more questions come in. So, David, the first one is, what are the biggest contractual and legal barriers that need to be overcome to enable full business as usual BIM adoption across the industry and through the full supply chain? Big question.
It is, but I think as I touched on in my presentation, Sarah, if you divide the BIM between the legal aspects and the technological aspects, I think from a legal point of view, I don't see any particular legal barriers and contractual ones to overcome. Obviously, I mentioned the risk of there being conflicts between documents, but all these can be ironed out. I think as long as the parties know exactly what they're signing up to and all the documents talk to each other properly and align properly, I don't see any contractual and legal barriers in the way at all at the moment.
Thank you very much, David. And staying with you, a question from Alex Speechley at AA Projects, who says that we often act on behalf of academy schools, which are charitable trusts, but receive grants from the government, albeit it is in effect indirect procurement. So do you think BIM Level 2 will apply in this case? Interesting.
You'd have to look exactly, Alex, at the specific provisions in the Level 2 government BIM. I don't know the answer to that off the top of my head as to how far it has to be a direct public body or whether in effect indirect would catch it as well. We need to look in the detail of that one, Alex, really.
Thank you very much, David. Do keep the questions coming as we've got time for just probably one or two more. The first one I'm going to take at the moment, though, is back to Jatinder on the subject of Brexit. A question from John Parson at Pearson Fraser, who says that public procurement and specifically EU directives do not, in his view, complement two-stage tendering. Is it anticipated that new considerations of public procurement will address this? Jatinder.
Well, very good question. I think he's right. I don't think public procurement rules do allow potentially particularly well for two-stage tendering. The question then, though, is, again, it depends on which route the UK decides to go down. If we are looking to continue and stay in the EEA, then I think, as I said previously, I don't think there'll be very much changes to the EU procurement route or regulations or legislation at all. But if we choose not to, then I don't see why there's no reason why the government can't then look into this particular concern. And yes, you're right. We should use this as an opportunity. As I say in my slide, is Brexit we have potential opportunities. Maybe that's one of the opportunities that we can consider going forward, is to adequately allow for two-stage tendering in the context of procurement.
Thank you very much, Jatinder. We're now going to go back to the topic of BIM again. A question from Richard Charles for David. Do you know of any cases which have been to court where BIM information has resulted in the designers being found at fault, or where that information model content has been used for other projects without permission?
I'll be honest with you, I'm not aware of any English cases. I was reading the other day about a case, an American case, where they had a BIM dispute, and it all related to the services in a ceiling. I think there was a very limited ceiling void, and the services had to go in a particular order. Unsurprisingly, they didn't go in that order. It wasn't picked up in the BIM model, and an almighty bust-up resulted. The only thing with this is we know that there was a confidential settlement agreed between the contractor and the client. So although it arose from a BIM issue, we don't know exactly who the finger was pointed at. But it does go to show really that BIM's not infallible. You know, the fact that the idea is that it's going to be the end of these sorts of clashes on site. It'll go towards preventing it, but it's not infallible.
Lovely. And staying on the topic of BIM, another question, I guess, about the scope of the BIM legislation. Will infrastructure companies such as Network Rail have to comply with BIM regulations?
Oh, again, I think much like the charities one, I'd have to look exactly at how far the scope of that goes, because Network Rail obviously is a private company, but to what extent with government funding it will be caught by the government regulations, I'd need to actually check.
Lovely. Thank you very much, David. And now just coming back on the EU again, I think you did cover this in your presentation, Jatinder, but just for clarification, would EU procurement legislation have to be vested in Westminster with further legislation? A question from Neil Ferguson.
It depends on when we're talking about. At the moment, EU legislation is obviously already part of the UK's legislation, and therefore nothing would change at this moment in time. And ultimately, it would continue to apply. The EU regulations would continue to apply because they are enacted under a UK law, under Act, which means that the only way we could actually get rid of that legislation is to revoke it. So if we do nothing at this moment in time, the current EU legislation will continue to apply. Now, going forward, any new EU procurement legislation that may come out, that at the period when we've actually Brexited and actually exited the EU, then at that stage, any new EU regulations that came out and we wanted to comply with here in the UK would have to be specifically enacted into UK law and wouldn't automatically apply. So it's a question of whether we're asking whether the current legislation will continue to apply after exit, which it will unless we revoke it, or are we talking about new legislation that comes in after our exit, which would require new legislation in the UK?
Thank you very much, Jatinder. Right, well, our hour's nearly up, so I'm afraid that that's all we have time for this morning. But just to remind you that the webinar will be available on demand through building.co.uk from tomorrow. So if you want to listen back or look at any of the slides, do go on the website from tomorrow. It will be up there for another year, so plenty of time for you there. So thank you all for joining us this morning, and in particular for sending through so many interesting questions. Finally, I'd like to thank our speakers, Jatinder Garcha and David Bebb, and to our sponsors this morning, Fenwick Elliott. Thank you very much.